Right now, if you ask 10 people affected by the so-called 75-country visa pause what is happening with their case, many will say it is still completely frozen. That answer is not entirely accurate, and the confusion around what changed and what did not is where the real issue lies. Some families are still checking their case status daily, believing nothing will move until Washington makes another announcement. The truth is more nuanced. The initial pause happened, but what happened afterward is what matters most for you right now. Here is a clear breakdown of what actually occurred. On January 14, 2026, the State Department announced that beginning January 21st, it would pause the issuance of immigrant visas, green cards processed at U.S. consulates abroad, for nationals of 75 countries. This pause applied only to immigrant visas. It did not apply to visitor visas, student visas like F1, or employment-based non-immigrant visas such as H-1B, O-1, TN, or E3. The stated basis was the public charge ground of inadmissibility. Public charge has existed in immigration law for decades. Normally, it is evaluated individually, based on factors such as income, age, health, and education. What changed in January was not the concept of public charge itself. What changed was the blanket pause in final visa issuance for nationals of listed countries. Cases continued to be scheduled for interviews, applications were accepted, but many immigrant visas were not issued, and cases were often placed into administrative processing under Section 221G. It is important to note that approved petitions were not revoked, and already issued visas were not automatically canceled. Cases were paused, not terminated. Around the same time, there were reports that adjustment of status cases, Form Y-485, filed inside the United States by nationals of those same countries, were also experiencing delays beyond normal processing times. In February 2026, litigation was filed in federal court challenging the pause. The lawsuit argued that the policy exceeded statutory authority and did not comply with required administrative procedures. On June 5, 2026, a federal judge ruled that the blanket pause was unlawful and ordered agencies to lift it. Following that ruling, immigrant visa processing was legally required to resume under standard procedures. The July 2026 visa bulletin cycle reflected a return to normal category-based processing rather than a blanket country freeze. However, this is the key point many people are missing. A court order lifting a pause does not mean every case instantly receives a visa. It removes the blanket barrier. It does not create automatic approvals or fixed timelines. Cases placed in 221G, administrative processing must still be reviewed. Adjustment of status applications must still move through regular USCIS processing queues. Consulates and field offices must work through backlogs that accumulated during the pause. For families whose interviews already occurred and whose cases were placed in administrative processing primarily because of the pause, this generally means cases should now return to individualized review. For employment-based applicants whose petitions became current but were stalled, adjudication should proceed according to regular visa number availability and processing capacity. For adjustment of status applicants inside the United States, cases should now move through USCIS under normal review standards, though normal processing still often takes several months. This is where proactive action matters. If your case was affected, do not assume silence means continued suspension. Check your case status directly through the National Visa Center portal, the appropriate U.S. consulate's system, your USCIS online account. Make sure your documentation is current. Medical exams can expire. Police certificates may need updating. Affidavits of support must reflect current income and household size. If documents lapsed during the pause, renew them promptly. If your case was refused under 221G and the refusal was tied to the country-based pause rather than a personal eligibility issue, you may want to consult a qualified immigration attorney to evaluate your specific circumstances. The most costly mistake right now is inaction based on outdated assumptions. The January pause felt indefinite at the time, but it was not permanent. The legal barrier was removed in June. What remains is backlog management and normal case-by-case review. If you stay documentarily current and monitor your case actively, you position yourself to move forward faster than someone who assumes nothing can happen until another public announcement is made. Processing times may still require patience, but the system is no longer under a blanket freeze. Stay informed. Stay proactive, and verify your case status directly rather than relying on secondhand summaries.